So we are the group 11 and our topic is all about separation and termination of employment. So what is separation and termination of employment? So separation and termination of employment is refers to the end of a working relationship between an employee and employer. So first, what is a separation? A separation happens when an employee leaves the company either by choice or due to circumstances. This is include resignation when the employee chooses to leave, retirement or job abandonment, when the employee stop coming to work without notice. It can also include layoffs or redundancy when where the companies no longer need the roles. So, and the termination is usually means that employer decides to then end employee's job. This can happen by reasons such as poor performance, misconduct, or company downsizing. And termination can be either with cause for a valid reason or without cause, often due to business changes, not employee's fault. So in both cases, there are important processes to follow. This include giving notice final pay and sometimes severance pay. There may also be an exit interview and return to the company property. So the goal of managing separation and termination, well, is to protect both the employees' rights and the company's interest. It also helps maintain a good reputation and work moral. So in simplest term, separation and termination are just the ways of ending job, but they should be handled carefully and fairly.
So here are the learning outcomes of this topic. After reading the chapter, the students should be able to, number one, cite the difference between just cases and authorized causes of termination. Number two, describe due process in the context of termination and employment. And last, discuss and explain the provision of the Labor Code of the Philippines on termination of employment and retirement from service. So the same provision also indicate the just causes of the resignation with cause. First, serious insult to the honor and person of the employee. Second, inhuman and unbearable treatment. Third, crime committed against the person of the employee or any of the immediate members of the employee's families and others analogous causes. And the second type of resignation, the employee need not to serve a written notice for resignation is not allowed and is considered as constructive dismissal. A dismissal in disguise employee retirement in either voluntary or compulsory in Act 287 of the Labor Code of the Philippines. So here the explanation of these cases. An employee can resign without notice if they experience serious treatment, threats, or similar unjust action from their employer. So, the dismissal of the employee and the Philippines. An equality of rights exists between employer and employee, while the employer cannot force the employee to work against his or her will. Neither can the employee compel the employer to continue giving him or her work if there is a lawful reason not to do. Thus, the employer may terminate the services of an employee for just unauthorized causes after following the procedure laid down by the law. But the employer has the burden of the proving the lawfulness of the employee's dismissal in the proper forum. So the discussion is, the explanation of this dismissal of employee in the Philippines is in the Philippines, an employer can dismiss an employee only for a valid reason or authorized reason. The employer must follow the proper legal steps before ending the employee's job. Both the employer and employee have equal rights under the law. It is the employee's duty employer's duty to prove that the dismissal was fair and lawful. And also, the dismissal of an employee in the Philippines is authorized in two causes. First, business reason, and second is disease. The business reason could be installation of labor-saving device, second, redundancy, third, retirement, and last is closure of cessation of operation are 283 Labor Code. So the explanation of this is in the Philippines, employee can be dismissed for authorized reason, which are either due to business needs or health issues. Business reason include changing that help the company save money or work more efficiently. Examples are using machines instead of people, having too many workers, needing to cut costs, or closing the business. The these reasons are allowed under the law, the proper if it is a process is followed. So also the dismissal of an employee in the Philippines, those hired or temporary basis, that is for a term or fixed period, are not regular employees, but are contractual employees. Consequently, there is no illegal dismissal when their services are terminated by the reason of the expiration of their contracts. Lack of notice of termination is of no consequences because a contract for employment for a different definite period terminates by its own term and end in such a period. So the explanation of this is employees hired for a specific period or term are called contractual employees, not regular ones. Their jobs ends automatically when their contract period is over. This kind of ending is not considered illegal dismissal. The employer also doesn't need to give the notice because the contract ends by itself. So, the severance pay with termination. As already noted, separation pay is required to be paid to the employee when there is a termination of employment by the employer of an authorized cause. The amount of which depend of the cause. If the termination is due to the installation of labor-saving devices or redundancy, the separation pay is 1 month's pay for every year of services or 1 month pay whichever is higher or Labor Code 283. So the explanation of this is and severance pay is given the employees when they are not let go for the authorized reason. The amount depends on the reason for the termination. If the employee is dismissed because of redundancy or the use of machines to replace workers, they are entitled to separation pay. This pay is either 1 month's salary or 1 month's pay for each year they worker, whichever is more. And my last topic or discuss is all about difference between a just and authorized cause of termination. Just cause refers a wrongdoing committed by the employer or employee on the basis of which the aggrieved party may terminate an employer relationship. Authorized cause refer to the cause brought about by the changing economic or business condition of employer. An explanation of this is a just cause means the employee did something wrong like breaking company rules which lead to dismissal. It is based on the employee's fault or misconduct. An authorized cause happens when the company has business or financial reason to let go of the employees. This is not the employee's fault but it is due to changes in the company's situation.
Good day, sir. My topic is all about the causes for termination by the employer. First is serious misconduct. Serious misconduct is generally defined as improper or a wrong conduct a transgression of rules, or derelictions of duties with wrongful intent. So serious misconduct goes beyond simple or ordinary misconduct. It must be of a grave and aggravated nature. So repeated minor offenses can be accumulated to constitute serious misconduct. Um, the severity is judged on a case-by-case basis. So considering the specific context of a company rules. Serious misconduct is a valid reason for an employee to terminate an employee. This means that employee committed a grave and aggravated offense impacting their works and demonstrating unfitness to continue employment. The misconduct must be work-related and show wrongful intent, not mere negligence or error in judgment. Willful disobedience or employer's lawful order connected with work. So, characterized by a wrongful and persevere attitude is a legitimate reason for dismissal under Filipino Labor Code law. This is codified in Article 297 of the Labor Code, allowing employers to terminate employees for serious misconduct or willful disobedience. Willful disobedience, this refers to the deliberate and intentional disregard of a lawful order given by the employer. It's not just a mistake or an oversight. It requires a wrongful and persevere attitude, uh, indicating deliberate refusal to obey. So, employer's lawful orders, the order must be reasonable and lawful rules. So, regulation or policy of the company, or it should also be communicated to the employee and related to their job duties. So, procedure. Gross habitual neglect of duty under the Philippine law refers to the serious and repeated failures to perform one's duties, characterized by a lack of cares or conscious indifference to the consequences. It is just a cause for dismissal under Article 282 of the Labor Code, meaning it justifies terminating an employee. Fraud or breach of trust recognizes just causes for termination under Philippine law. This includes situations where an employee deliberately violates the trust in them by the employer, such as through dishonest or manipulation of company resources. So, a fraud and willful breach of trust by employee are valid just causes for termination of employment. This means an employer can legally dismiss an employee for such action, provided they can prove the employee intentionally violated the trust placed in them. Commission of crime of offense against employer, employees, families, or representative. So this means the employer can legally dismiss employee in such situation. So under Philippine labor law, an employer may be legally dismiss an employee who commits a crime of offense against the employer, their family, or representative, provided the termination complies with substantive and procedural due process outlined in the Labor Code. First is Article 297 of the Labor Code, formerly Article 282 lists commission of the crime of offense against employers of or their immediate family representative as a just case for dismissal. This includes acts like theft, fraud, physical assault, harassment, or other criminal act directly tied to the just causes for termination by the employee. So, serious insult by the employer or his or her representative on the honor of person of the employee, serious insult by the employer representative. This applies when the employers or their representative commits grave offensive act that attack the employee's dignity, honor, person. Example include public humiliation, defamatory accusation, or threats that degrade the employee's character. So legal basis, Article 285 of the Labor Code allows immediate resignation without notice of insult, renders continued employment intolerable. So inhumane and unbearable treatment according to the employee or employers or his or her representative. Inhumane and unbearable treatment. This cover cruel or intolerable working condition imposed by the employer such as physical and verbal abuse, forced labor or unsafe environment, for instance, denying rest breaks, withholding wages, or subject for employees hazardous tasks without protection. Legally basis, court recognize this as analogous or serious misconduct under labor code justifying immediate resignations. So, commission of the crime by the employers or his or her representative against the person or the employer or any of these immediate members of his family. Commission of crime against the employer or family if the employers or their representative commits or criminal act, insult, threat, or threats against employee or their immediate family, spouse, children, or parents. Their employee may be resigned immediately. For example, a manager physically assaulting an employee, stealing property, legal basis. So, initial also support or employees intimate employment in such cases. um, Automized causes for termination. So, installation of labor-saving device. So, this refers to the introduction of machinery or technology that automates tasks previously performed by human workers. The company may choose to install this device to increase efficiency, reduce costs, or improve productivity. So, redundancy. This occurs when an employee's position becomes unnecessary due to change within the company, such as overhiring, increased business volume, or discontinuation of a product line. Retrenchment to prevent losses. So, improvement during the workforce for to prevent financial losses or to stop a decline in the company capital. It is a cost-cutting measure taken to ensure the company's survival. Closure or cessation of a business. So, this involves the complete or partial shutdown of business due to financial losses or the other reason. The company may decide to close down entirely or to shut down a specific operation or department. So, dismiss not curable within 6 months are certified by the competent public authority, and continued employment of the employee is prejudicial to his or her health or to the health of his or her co-employee. Due process in the context of termination of employment. So, due process in the Philippines means that the employees or the employee has the right to be informed of the reason for their dismissal and to have a chance to defend themselves. This implies especially when the dismissal is based on just causes like misconduct or neglect of duty. First is the substantive due process. This means that the reason for dismissal must be legally valid. It must be based on the just cause like misconduct or unauthorized cause like business closure. It, it, if the employer doesn't have the valid reason, the dismissal is illegal. Second is the procedural of due process. This means the employer must follow the specific steps to ensure fairness. So, the employee must be given a written notice explaining the reason for dismissal and allowing them to respond. In hearing, the employee has the right to hear where they can present their sides to the story of challenge the employer's evidence. In the written notice of determination, after the hearing, the employer must have the issue or the final written notice stating the decisions. And that's all. Thank you.
Good morning, sir. My topic is all about the Labor Code of the Philippines. So, it means the Labor Code, thereby revising and consolidating labor and social laws to afford protection to labor, promote employment and human resources development, and ensure industrial peace based on Social Justice Book 6 Post-Employment. Title 1, Termination of Employment. So, the Article 278 coverage, the provisions of this title shall apply to all establishments or undertaking whether for profit or not. So, it means that any business or organizations regardless of its size or purpose, is subject to rules regarding termination of employment outlined in the sections of Labor Code. So the Article 279, security of tenure. So in cases of regular employment, the employer shall not terminate the services of an employee except for a just cause or when authorized by this title. An employee who is unjustly dismissed from work shall be entitled to reinstatement without loss of seniority rights and other privileges. So it means it ensures that once an employee is deemed regular, their employment is protected and they cannot be um, terminated. That regular employees have a right to continued employment as long as they are not terminated for just cause or authorized reasons. Article 280, regular and casual employment. The provisions of written agreement to the contrary, notwithstanding and regardless of the oral agreement of the parties, an employment shall be deemed to be regular where the employee has been engaged to perform activities which are usually necessary or desirable in the usual business or trade of the employer. So except where the employment has been fixed for a specific project or undertaking, the completion or termination of which has been determined at the time of the engagement of the employee, or where the work or service to be performed is seasonal in nature and the employment for the duration of the season. So it means the employment shall be deemed to be casual if it is not covered by the preceding paragraph. So they provided that any employee who has rendered at least 1 year of service, whether such service is continuous or broken, shall be considered a regular employee with respect of the activity in which he is employed, and his employment shall continue while such activity exists. Article 281, provisional employment exceed 6 months from the date the employee started working, unless it is covered by an apprenticeship agreement stipulating a longer period. The services of an employee who has been engaged on a probationary basis may be terminated for a just cause or when he fails to qualify as to regular employment in according with reasonable standards made known by the employer to the employee at the time of his engagement. So it means an employee who is allowed to work after a probationary period shall be considered a regular employee. Article 282, termination by employer for any of the following causes. So number one is, first is serious misconduct or willful. So disobedience by the employee of the lawful orders of his employee or representative in connection with his work. And second is gross and habitual neglect by the employee of his duties. And the third is fraud or willful breach by the employee of the trust reposed in him by the employer or a duly authorized representative. And the fourth is commission of a crime or offense by the employee against the person of his employer or any immediate member of his family or his duly authorized representatives. And the last one is other causes analogs to the foregoing. And the summary of this, Before terminating an employee, the employer must provide the employee with a written notice detailing the grounds for termination and opportunity to be heard. The employee should also be given a chance to present evidence in defense. Article 283, closure of establishment and reduction of personnel. So the employer may also terminate the employment of any employee due to the installation of labor, saving devices, redundancy, retrenchment to prevent losses of the closing or cessation of operation of the establishment or undertaking unless the closing is for the purpose of circumventing the provisions of this title by serving a written notice on the workers and the Ministry of Labor and Employment at least 1 month before the intended date therefore. And so it means specifically it allows for termination if the closure is not intended to circumvent of other provisions of the labor code and if proper notice is given to both the employees and the Department of Labor and Employment, duly affected workers and are entitled to separation pay. Article 284, disease as a ground for termination. An employer may terminate the services of an employee who has been found to be suffering from any disease or and whose continued employment is prohibited by law or is prejudicial to his health as well as to the health of his co-employees. So it means it allows an employer to terminate an employee who is suffering from a disease if the continued employment is either prohibited by law or prejudicial to the employee's health or the health of their co-workers. So this termination is considered an authorized cause. So for example, his continued employment is prohibited or prejudicial, so the disease must prevent the employee from continuing their work due to legal restrictions or the potential harm it poses to their health or the health of their colleagues. So, for example, is suffering from a disease, so the employee must be diagnosed with a disease. Then so their continued employment is prohibited or prejudicial. Article 285, termination by employee. First, an employee may terminate without just cause the employer relationship by serving written notice on the employer at least 1 month in advance. The employer upon whom no such notice was served may hold the employee liable for damages. The second, an employer may put into the relationship without serving any notice on the employer for any of the following just causes. So this means there are also certain just causes for an employee to resign, which are specified in other parts of the labor code, such as serious insult, inhuman treatment, or in crime committed against the employee or their family. And now, Article 285 allows employees to terminate their employment without a just cause by giving proper notice. Article 286, when employment not deemed terminated, the bona fide suspension of the operation of a business or undertaking for a period not exceeding 6 months or the fulfillment by the employee of a military or civic duty shall not terminate employment. And so it means in these cases, the employer must reinstate the employee to their former position without loss of seniority if the employee indicates their desire to resume work within 1 month of the suspension ending or the return from military or civic duty. If, for example, a client disengages from the company, the employer has the option to either retrench the concerned employees outright, provided that all requisites for retrenchment are present, or suspend the employment of the concerned agents temporarily on the condition that they will be prioritized on the next hiring rounds. If no such hiring occurs or the employee cannot be transferred to other department accounts within the period of temporary suspension, retrenchment may again be considered. So the best way to go about this is to conduct a special town hall meeting with the concerned employees along with a duly representative for the purpose of informing the same of their options regarding their tenure with the company. So that during this meeting, the employer should inform the employees of the consequences of retrenchment and temporary suspension of the employment relationship. And so in addition, the employer should also inform the concerned employees that they have the choice to either be retrenched or to be put on floating status with the same condition mentioned. So those who opted for retrenchment or determined where such employees may be transferred upon availability of or available of work.
Employee termination is the Philippines is strictly regulated, especially for regular employees, due to constitutional protection against involuntary servitude. Employees have the right to resign with or without cause. Resignation without cause requires 30 days written notice. Failures to do so can result in liability. Resignation with cause, serious insult, inhuman treatment, crime against employee or family, or similar reason doesn't require notice. Forced resignations are illegal and constitutes constructive dismissal. Next is the Philippine law grants equal rights to employers and employees. Employers can terminate employees for just cause like employee misconduct, just a serious misconduct or thief, or authorized cause business reason like redundancy or closure or incurable disease. However, the employer must prove the legality of dismissal. Temporary or contract employees can be let go without cause at the end of their contract. Notice that is not required.